three thank yous. First of all, to you all for coming on the second day of the English cricket season. And secondly, to Matt and the Oxford University Press for organising this party with some assistance from my clerk, who is also here. But lastly, and by no means least, we're very privileged to have Lord Neuberger, who has one of the most congested diaries in London, who's managed to come here to give this rather splendid volume its launch. Thank you very much.
I shall be characteristically lengthy. Lawyers, like politicians and journalists, are very familiar with the power and importance of words, and more particularly with the information that words can convey. That's why the right to communicate to other people facts, opinions, thoughts, impressions has been characterised as perhaps the most fundamental of all the freedoms. I believe that the first time that the right appeared in any constitutional document was when freedom of speech in Parliament was enshrined in the English Bill of Rights Act of 1689. But now, helped by Johnny-come-latelys in USA and France a century later, the central importance of freedom of expression is universally accepted, albeit in some totalitarian regimes only in theory. And the power of freedom of expression is also recognised, as indeed some might say confirmed, by those totalitarian regimes which repress it. But as usual, power carries responsibility with it, not least because the power of free speech can be used for evil purposes just as much as it can for good. Misused, freedom of expression can cause very serious damage. Racial hatred and general panic in a mass sense, or reputational damage of personal violation on a more individual basis. And living as we do in an age of human rights and electronic communication, where we are more aware than ever of the power and importance of freedom of expression and the need for responsibility of its exercise. Now, one of the functions of the law is to curb the general right to freedom of expression in order to protect other rights, but only to the minimum extent necessary to achieve that aim. The criminal law comes into play in relation, for instance, to inciting racial hatred or causing a breach of the peace. The civil law's most significant contributions are in the fields of privacy and defamation. Privacy, I think, is something of a Johnny-come-lately so far as English law is concerned. But since it emerged fully formed on the 2nd of October from the womb of the Human Rights Act through the agency of the parliamentary midwife, it's developed prodigiously, making up for lost time. Defamation, on the other hand, is a very much older sibling, having been part of our law for at least 700 years. However, even after all this time, the parliamentary midwife is not without her magic, as the Defamation Act 2013 shows. Defamation law is not only important, it's also very difficult, as I know from two bitter experiences. At the bar, my practice was in property law, principally landlord and tenant. After a particularly vituperative dispute, my client, a tenant, believed that after he had successfully defeated his landlord's claim, he had been libelled by the landlord, and he instructed me to settle defamation proceedings, which rather unwisely I did. The result was the humiliating experience of a master striking out my statement of claim for disclosing no cause of action. At the end of what was a thoroughly bruising experience, Master Elton, whom the more ancient among you may remember, avuncularly suggested to me that for the future I should stick to property law. And so I did, until I got to the Court of Appeal. With equal lack of wisdom, I allowed an appeal against the decision of Michael Caldecott, only to be shown the error of my ways by the Supreme Court and flood of the Times newspapers, who reinstated Michael's judgment. Whether I should be pleased or insulted that they took 203 paragraphs to reverse me, I'm not sure, but reverse me they did. None of this stopped me as Master of the Rolls from thereafter hearing defamation appeals, and indeed from agreeing to appear before the Joint Committee of both Houses when considering the defamation bill. At least I had the good sense to have Michael Caldecott join me and let him answer all the difficult questions. Indeed, I remember one occasion where there was a question I thought I could answer, and I jumped in and a rather cross lady peer said, actually, the question was Justice Tugendhat. So back in my box. But what's clear from all this is that I'm just the person who could benefit from a new book about defamation law. And I'm not the only one. The 2013 Act has now put into statutory form the need for a claimant to show serious harm to reputation, for corporate claimants to show serious financial harm. It also enacts the Reynolds defence, extends the law on qualified privilege, and attempts to deal with the alleged problem of libel tourism. All new statutes are opportunities for litigation, and the 2013 Act will be no exception, and no doubt that suits virtually everybody here. More generally, though, we live in a world of media intrusion via the internet, bloggers, tweeters and Facebookers, with the international jurisdictional issues that they bring, as well as the excitements of the more traditional media outlets via newspapers and broadcasters. We're in a world where Article 8 and Article 10 rub up against each other, where the statutory and common law provisions on privacy and confidentiality, data protection, freedom of information, the right to know, the right to be forgotten, the impossibility of keeping confidences confidential, defamation and malicious falsehood, injunctions and super-injunctions all need to be explained. And then there are the issues raised by the Leveson inquiry and phone hacking trials. And on top of this, there is the question of costs in a field without legal aid, with capped success fees, and where the Strasbourg court, as usual, has views. It's clear that Matt Collins, SC, is just the person to write a book which penetratingly analyses all these important developments in a clear and practical way. He's had great experience of legal practice in all the Australian jurisdictions, as well as in the academic world. He's already written a book considering in depth defamation on the internet, and has valuable legal experience outside defamation. And on top of that, he has one foot in Australia and another in the UK. Anyone who's read many judgments of Luxembourg Court, which have to be the joint view of all the judges in one judgment, whatever they really think, will know the benefit of having the views of a single person in a book. And that is what you will get in Matt Collins' book. He's acquired a very good pedigree, if you can acquire a pedigree, by becoming a tenant at One Brick Court, who are, they would no doubt say, others might say one of the two largest, best-known defamation chambers in London, and therefore, of course, in the world. I've had the pleasure of appearing in front of Patrick Neal and David Hurst, sitting with David Eadie, upholding Victoria Sharp, and normally upholding Michael Tugendhat, with one dishonourable exception, hearing submissions for Richard Rampton and Andrew Caldecott, all very distinguished members and former members of chambers. In my ill-fated outing before Master Elton, I was clutching a very recently acquired, very unused edition of Gatley, a book I've had cause to look at several times since becoming a judge. I've also had cause to look at Duncan and Neil on a number of occasions. My friend Edward Garnier tells me that Gatley is the family Bible of defamation, large but full of good stuff. And Duncan and Neil is the book you take to court in a short, sharp-fire fight. Matt Collins' book seems to bridge the gap between the two. From my less informed perspective, that seems to be absolutely right. It is a book which, in this dangerous world of defamation, as I know to my knowledge, both having tried it once to my great cost, and even more, unfortunately, to my client's cost at the bar, and having tried it on a number of occasions on the bench, is an area where you need enormous assistance. And Matt Collins' book, from my perusal of it, is one which no person practicing in the field of defamation, whether as a barrister, solicitor, or dare I say, as a judge, can do without. I highly recommend it. Thank you very much indeed.